Your mic can proceed.
Oh, thank you, Your Honor. May it please the court. My name is Alan Poppy. I represent the appellant Ivy Chase Apartment Property LLC. Just as a matter of a preliminary matter here, you probably noticed that the party names are quite similar. So Ivy Chase Apartment Property and Ivy Chase Apartments. Just to avoid confusion, I'm going to refer to my client solely as the appellant and the appellee solely as the appellee. Notwithstanding that, we are the appellant because we were the first to file, but the majority of the issues in this case have been raised by the cross appeal by the appellee. I'll be reserving 5 minutes for rebuttal to address some of those issues.
All right.
For my oral argument, I'll address our issue, which I think is a straightforward legal matter. And then I would like to address, I think, what would be the central issue in their cross appeal, which is the sufficiency or insufficiency or inadmissibility of the evidence submitted with regards to the unpaid principal balance. And if this court should agree with the appellee, what the court should do on remand. So with regards to our appeal, this is a commercial foreclosure case. My client obtained a final judgment of foreclosure. In that final judgment of foreclosure, the trial court did not award default interest as provided for in the contract in the promissory note, but instead awarded interest at a rate of only 5% based solely, quote unquote, on equity, because the court was sitting in foreclosure and it decided to do this because of it being in equity. This is improper as a matter of law. This is the Smiley v. Manufactured Housing Associates case from this district.
Mr. Poppy, if I'm correct, the source of your claim for default rate interest is in the December 1, 2010 renewal promissory note. Is that correct?
That's correct, Your Honor. That's correct.
Where default rate is defined, and it says after the occurrence of an event of default, the note and all sums due hereunder will bear interest at the maximum allowable rate permitted by law.
That's correct, Your Honor. That's the default rate. Also in the note, I'm sorry.
Go ahead.
Okay.
Go ahead.
Also in the note, there's a provision provides the event of default, which talks about that the remedies accorded in here can be raised at any time and without any additional notice and demand. So the note clearly talks about a default rate. And under Smiley,
the note we're operating on is the December 1, 2010 note. And I kind of cut into the chase. Your opposing counsel is arguing that there were a number of, I don't know whether it was invoices or what sort of documentation that came your way indicating that it should be only a 5% interest rate. And so what is your response to that argument?
Sure. My response, and I think the general theme that I wish for you to take away from my oral argument, is that we have to take the court's word for it. Okay. And what I mean by that is this. They have made this argument that they submitted evidence with regards to an affirmative defense of waiver, affirmative defense of estoppel. Two things happened in the trial court. Trial court said, one, those were unpled, and two, there was not sufficient evidence with regards to those defenses. And I quote from the court, "I don't believe that's an issue that's been properly raised. I don't find there's evidence before this court of one waiver or two usury based on my review of the file itself." The court then went on to say, but this is a court of equity. Based on that, since we are a court of equity, I find the defendant, the interest rate should carry with this note is 5%.
Your position is pretty cut and dried and easy to follow. You're claiming entitlement to this default rate under the renewal promissory note, and nothing should stand in the way of that. Certainly not the judge's rationale that because it's an equity court, he can disregard the 25% and only award the 5%.
That's correct. I would say our argument is very cut and dry and very straight. I think under Smiley, which Smiley clearly said that you cannot, the court was without authority to modify the terms of a note and mortgage by failing to give effect to a default interest rate of 18%, that when a contract is clear, it's unambiguous. The court cannot say just because I'm in equity disregard that language. And I think the court did exactly what Smiley said you're not supposed to do. It looked at these defenses. It said, factually, legally, they don't meet the burden. They're not there. I'm going to deny them. But then the back of their mind said, I'm still going to help you out in equity, not grant default interest. And that's what Smiley said you couldn't do.
What is your thinking about what the judge did and why he did it? Do you think it was just because the 25% would be so extreme in terms of the amount of the recovery, or is there any indication as to why he decided to go that way?
Right. I don't really want to put words in the judge's mouth. I think,
I guess all we know is what the record says.
It was what the record says. I think the judge did exactly what happened in Smiley, and what Smiley said you can't do is that because there was some evidence put on, that even though this evidence didn't meet the burden and the level, I'm still going to help you out in equity and say you don't get the 25%. What happened in Smiley was there was an accusation against the mortgagee there that they had breached a partial release. Okay. The appellate court, this court reversed that. The mortgagor said, look, with regards to foreclosure, you still should not grant default interest because there was this issue with the breach of the partial release. The court said that doesn't matter. And I quote from this court, it said, given the facts of the case, we hold that even if the trustees had breached the independent covenant pertaining to partial release, the trial court was without authority to modify the terms of the note and mortgage by failing to give effect to the default rate provision. So I agree with you 100%. Our argument is fairly cut and dry. We have to take the court's word for it that it did this solely because it was an equity. It denied the defenses, and I think that it properly denied the defenses. There's an anti-waiver provision which says that any amendment or modification has to be signed and in writing. There was no evidence of that. The only evidence that was submitted was a letter, a signed letter indicating that the loan was being transferred to a new assignee. It didn't mention anything about the interest rate. With regards to the estoppel defense, they were required to put on evidence of reliance and a detrimental change in position. There's no evidence in the record of that. There's no argument made in their papers about detrimental reliance. And what they tried to do in the trial court was put on evidence through their property manager, another company, Jotar Management, which tried to talk about what the appellee would have done had they had some notice of this. And the court properly sustained an objection to that testimony. So there's no evidence to support the estoppel defense. There's no evidence to support the waiver defense. The court denied it, and I think what it tried to do was improperly backdoor in that, and that's inappropriate clearly under Smiley. So what we would ask for is this court to reverse that portion of the final judgment that awards interest only at the rate of 5% and instruct the court to award interest at the default rate appropriately calculated. With regards to the cross appeal, I think the central issue is this issue of the sufficiency or admissibility of the evidence the appellant submitted with regards to the unpaid principal balance due.
Well, is it admissibility or is it that none was admitted? I mean, in other words, I guess it could be characterized two different ways. One way is can a witness testify to something regarding documents that were not submitted? I don't know if that's a best evidence rule or whether that's a failure of, but you seem to rely on the business records exception to hearsay, but the hearsay, the records need to be admitted. What case stands for the proposition that there's some alternative method of proving the amount of indebtedness without admitting the records upon which the witness is relying?
Right. So my response to this is this, and thank you for the question, because that gets directly to the point. I concede that the trial attorney did not submit the records into evidence. So the witness clearly testified that he did review records, but they did not submit them in evidence. And I'm aware of the Sauce case from this district, which says, oral testimony regarding the amount due without the records is inadmissible. I got that. I think that's correct. This case is a little bit different in the sense that on cross-examination, they did bring up, the appellee did bring up records regarding a different amount.
So in what case do you rely on that you can rely on cross-examination?
Right.
Well, during cross-examination,
Your Honor,
during cross-examination, how could they, that wasn't even their case in chief, so how could they have admitted documents
right.
during cross-examination?
So let me explain. So in cross-examination, they brought up, they said the appellant testified as to an amount due of $1,122,538. On cross-examination, they asked Mr. Geigel, the witness, whether he was aware of documents that had a different amount. He agreed. On redirect, the appellant's counsel asked him about those documents and asked him whether he would accept the amount due if there was any dispute as to what was due. Would you agree to accept that amount in those documents? He said yes. Those documents were then introduced into evidence in the appellee's case in chief. Okay, so I agree. I admit the record is clear. They were not submitted in the appellant's case in chief. They were submitted
but something happened prior to the defense case in chief. Well, many things happened. One, generally speaking, there were objections made based on hearsay. Mm-hmm. And two, there was a motion for involuntary dismissal. That's so correct. We are on appeal as part of this appeal from a final judgment is a denial of a motion for involuntary dismissal, which we could conclude was erroneous because at that time, the case in chief of the defense had not been put on and none of these documents had been entered into evidence.
Your Honor, look, I'm aware of the Sauce case. I think if this court followed the Sauce case, that would be the finding. I think it's a little bit different. I think there is some basis for this court to say that the trial court's award was appropriate based on there was not a dispute as to these documents and as to the amount owed. There was no other documents submitted with regards to the amount owed. So I understand your point. I agree. From purposes of the case in chief with regards to the appellant, the documents were submitted. But the argument is the documents came in under the appellee's case. And what the appellee is saying is, look, these documents that we've all talked about with regards to the amount due, what you agreed to accept is the amount due, and there's no other documents, you should have submitted them in the case in chief. And because you didn't, let's throw out the baby with the bathwater and dismiss this case. So
let me ask you this as a threshold question. I see where you're going, and I'm sure you can regain your train of thought. But let's just presume.
I'm happy for the colloquy. So go ahead. Thank
you. Let's just presume, for the sake of discussion, that you can rely on records adduced by the defense in its case in chief to cure an erroneous denial of a motion for involuntary dismissal. Were the documents completely supportive of the necessary element of your claim, which is the amount of indebtedness? Were the documents adduced by the defense, did they support every aspect of the plaintiff's claim, an element of which is the amount of indebtedness?
These are account statements that were issued by a prior servicer. They indicated an unpaid principal balance. So I think they would be sufficient in and of itself. This case is.
Now, what about the insurance and et cetera?
Right.
With regards, completely supported.
Yeah, Your Honor, we have to concede there were no documents that were submitted in support of that. I think some of that with regards to roof repairs and those things, he testified from his personal knowledge because he paid for them. Some of those documents are from the receiver, but I'll agree with regards to his testimony on those items. He did not testify from documents that were submitted into evidence. He testified that he looked at the documents, testified that he was testifying from those documents, but I have to agree with you, they were not submitted into evidence. Jumping back, if I will, as you said, hopefully regaining my train of thought. And I want to kind of just finish the point about the evidence that was submitted. This is a 1 year note. There was a small window in 1 year which they can pay interest. It matured. It was not paid upon maturity and therefore went in default. So for purposes of the evidence, this is not a case in which there's a 5, 10, 15-year course of a payment history that needs to sort of detail out that amount owed. I think account statements coming out after the maturity and the default are sufficient to support the unpaid principal balance. There's testimony that there was no payment made after maturity, and that's not been contested or rebutted. So, you know, I don't think this is a case where I need an account statement issued in, December 2021 to establish what the unpaid principal balance is, because there's not that that payment history. But talking about the issues, I think you've clearly identified the issue. I think you're clearly troubled by the fact that the documents weren't submitted into evidence. I understand that. I understand what the Sauce case says. The issue then becomes, what do we do about it? And I think this is a case that's not appropriate to involuntarily dismiss. The remand instructions that are available to this court are clearly within this court's discretion. That's the Tracy case. They're bounded by issues or questions of equity and fairness. And I quote from Tracy that while there is a strong preference for finality, an aversion to a second bite of the apple, and Tracy, this court acknowledged that, quote, on occasion, there may be exceptional circumstances that in fairness merit a return to the trial court for further adjudication following appellate court's decision. This court recently in 2020 in the Mace M&T Bank case reiterated this principle of law and said that appellate courts retain discretion to remand for further proceedings, notwithstanding a failure of proof in cases presenting exceptional circumstances in which the interests of equity and fairness call for an extra bite of the apple. So in this case, what constitutes those exceptional circumstances? Are there exceptional circumstances? What does equity and fairness dictate? And in our papers, we talk about Tracy and equity and fairness. We also talk about this line of cases there, for lack of a better
Mr.
term.
Coffey, I failed to give you your 5-minute warning. You're at 3 minutes. Do you want to stop and I'll give you the 5 minutes?
I'm at 3 minutes. Do I use up my whole 20 or 3 minutes to my 5-minute rebuttal? I'm sorry.
Do your whole 20.
My whole 20. I will reserve, I guess, my 3 minutes to.
Yeah, I'm going to bump it to 5. Since, all right. Let's move
Thank
on
you,
to your opponent. You're welcome. Mr. Hayes.
Good morning, Your Honor. May it please the court, my name is Jonathan Hayes, representing the appellees and cross appellants, that is Ivy Chase Apartments Limited and Gail Curtis, which I'll refer to collectively as the appellee or as Ivy Chase. And I'll refer to the opposing party either as appellant or as property LLC. Of course, we did file a cross appeal, so I would also like to reserve 5 minutes of my time for rebuttal.
All right, you got it.
Ivy Chase requests that the judgment below be reversed with instructions to dismiss. The appellant failed to meet its evidentiary burdens in multiple respects, including the failure to prove its damages and the failure to prove standing. Also, the record reflects that appellant forfeited the right to collect the debt at issue by seeking a usurious rate in 2 different respects. First, in charging a rate in excess of 25% as the stated rate, that is mathematically.
What is the remedy? If usury is an issue, what's the remedy?
We believe that instructions for involuntary dismissal is the remedy, Your Honor. They forfeited
You forfeit basically everything, principal and interest. Is that true?
That's right, Your Honor.
Does the court under those circumstances have any equity powers to just reduce the interest to a non-usurious level?
Your Honor, I don't believe so. The statute at issue.
Yeah, no, I'm just trying to find out why the court did what it did. Did it say there was usury involved, or it didn't even cover that? That's not a finding of fact we can deal with.
Your Honor, I think one of the issues that doesn't quite jump out from the record is that this was not a case that occurred over 3 days. The original hearing, I believe, was set for a single hour with no consultation. There were no documents exchanged from the appellant to Ivy Chase. and it was as a result of issues that arose during that hearing that the usury issue appeared, and that the usury issue sort of came to fruition during that hearing. The court.
Is that because of the 360-day calculation?
In part, it is because of the 360-day calculation. It is also because of the excess consideration demanded and sought.
What are the cases that talk about that? The excess consideration becomes part of the interest calculation.
Your Honor, I would point the court to Jersey Palm Gross Incorporated versus Paper, which is we cited in the court. It's a fourth UCA opinion from 1994. That was approved by the Florida Supreme Court in 1995 as well. And they provided that such obligations may be considered interest and can render a loan usurious. And the definition there was, if a borrower is required to pay any bonus or other consideration, I would suggest that in this context, it is consideration under the contract standard. That is, was it any detriment to the payer?
So what was it? What was it they had to pay that we need to calculate? We need to factor into the calculation of interest?
Your Honor, there's three. Certainly. So, Your Honor, in addition to the mathematical calculation related to the interest, which I think is laid out very thoroughly by the First District Court of Appeal and agreed to by the Attorney General,
what was it in this case?
What was the excess
benefit? The benefit that we're supposed to factor into the calculation of interest.
Thank you, Your Honor. First, it would be excess taxes. It would also be excess protective advances and excess principal.
So what were the benefits in that case you're relying on?
I don't recall, Your Honor. That's not true. In that case, the excess benefit was, in addition to the interest, the borrower agreed to turn over a certain amount of equity in the company. And when you added up the value of the equity in that company, and you added that to the interest, that is the value in the company, the reasonable value of the company on top of the interest, it added up to over 25.
So let me get this straight. So you did not assert a defense of usury. The contract that your client entered into contracted for a 25% default rate. There was a clause that, the savings clause, so to speak, that said, it wasn't even a 25%. It was maximum allowed by law, which happens to be 25%. And then you said, was it at trial or when evidence is adduced and your theory, your unpled defense now is that because there were benefits to the lender that can be calculated to push this rate that they were seeking. They just said, we just want 25% because that's what the law says. And now your unpled defense is supported by evidence of benefits to the lender that under this 1994 case, it can be can be factored into the calculation of interest for the purpose of usury.
Your Honor, first I'd like to address the timeliness issue. We did timely move to amend our pleadings under Rule 1.190B. And it was before the judgment in this case. In fact, it was during the hearing at this case that we timely moved to amend the pleadings. I would suggest that the court improperly denied that. In some respects, this was a bit of a trial by ambush. We showed up, and when this defense appeared, there was no reference at any time to a 25% interest that was sought.
How did that prejudice you? They show up and they said, look, here's the contract. You haven't paid since 2011. You were in default. Not only is your client in default, that's law of the case. You're in default. You failed to cure. That's law of the case, which goes to another couple of your issues, which I would like to talk about. And they show up and like, well, it's law of the case here. I guess at that point it hadn't been law of the case, but there's default, no cure. This is the contract says this is what we want, 25%. So how are you prejudiced by enforcing the agreement into which your client entered?
Well, Your Honor, one of the issues is the principal amount, and the excess principal amount that was demanded should constitute part of the consideration, part of the excess interest. that should count on top of the illegal rate of usury, the illegal rate of interest that's calculated in this case. And so as to the law of the case, Your Honor, just to go back and address the first question I think you had, was the only thing that is the law of the case at issue is whether or not Elizon, one of the predecessors in interest of the appellant, had standing in this case. That's certainly established. There's no question about that. We have.
So you're telling me that in the first case, the default and notice and failure to cure was not established. There was a final judgment of foreclosure, and the only thing the only basis for the, I forget what was a motion for relief from judgment, but the only basis, or motion for rehearing, the only basis upon which that was granted was standing. And then this court reversed on standing. And then you're telling me that there was not law of the case, that there was default, notice, and failure to cure?
Your Honor, because the original final judgment of default was vacated by the lower court, that original judgment simply becomes a nullity, Your Honor.
Based on why was it vacated?
We moved for rehearing, and we moved for.
No, on what basis was it vacated?
It was vacated on the basis of standing, Your Honor. Right,
which was reversed. So now you're telling me that, and then this court clarified that, hey, the only thing that we adjudicated was what was on appeal, which was standing, and so we overturned. Essentially, let me ask this: could I characterize this? Can you remind me whether it was a motion for relief from judgment or a rehearing, or what was it?
I believe it was a motion for rehearing, Your Honor.
Okay, so motion for rehearing
at the trial court.
Yeah. So, and that was what was on appeal, which was a granting of motion for rehearing. And then they reversed. We could I characterize this way: we reversed the granting of the motion for rehearing, which would have meant that the final judgment of foreclosure, absent damages, the amount of damages which was reserved, is law of the case, which would include standing, default, notice, failure to cure.
Respectfully, Your Honor, I think there's a critical issue there's two critical issues in there. One is procedural and one is factual. The factual issue, I think, is the stronger of the two. That is that while the payment history at issue was not entered into the record, the appellee, that is Ivy Chase, should be entitled to payments that were made from rents, and those would be reflected in a payment history. That would have decreased the principal amount, even below the amount.
I didn't say anything about an amount of indebtedness. I just said standing, default, notice, failure to cure.
And the procedural issue that I think that is at issue there, Your Honor, is certainly that in addition to the court granting a motion for rehearing, the court then held a hearing the court reversed itself on summary judgment. It held a hearing, which it referred to, the trial court referred to as a trial. The appellant requested and received the right to proceed in that trial only on the basis that we had raised. That is, it proceeded only on the basis of standing. It chose at its own peril to rely entirely on the record at summary judgment as to those other issues. It never requested a written ruling for under 1.510D. There was no order related to a partial summary judgment in this case under 1.510D. There was no issue. There was no reason for an appellee to raise those issues prior because the court vacated its final summary judgment in its entirety. The appellant cites to a single order as it relates to the partial summary judgment under 1.510D. That is merely a one-line order with no factual findings at all.
Let me ask you this. So I think I can see where you're going. So then it comes back and there's a trial on damages and you move for involuntary dismissal. Did you move for involuntary dismissal based on failure to admit into evidence in the trial on damages, the original, or a copy of the original note, or the original actually is trial? So your argument has to be it's the original.
That is one of the arguments, Your Honor. Yes.
So in the motion for involuntary dismissal, you said, well, hey, why didn't you, you have to enter the note again that Elizon had entered when it first obtained judgment of foreclosure.
Your Honor, one of the issues at trial was that I think this does appear.
Which trial? The trial on damages?
Right. At the trial on damages, Your Honor.
Okay.
If you look at the record,
okay.
we're not given the opportunity to fully flesh out all of the bases on which we move for dismissal. The entire first hearing after the plaintiff rested was
so right. So the court that sounds like the court agrees with me, which was that has already been adjudicated. The standing of the predecessor was already adjudicated, and the right to foreclose at the first trial. So at the first trial, there was standing at the time of inception and standing at the time of trial, and And it sounds like the court agreed with me that that's not on the table now. Elizon, that was immediate predecessor, right? Elizon proved, and I got reversed. I'm just speaking for the trial court and my perception. I got reversed on standing. So, hey, counsel for Barr, I'm sorry, I'm not gonna get into any of that. Elizon proved standing at inception, and Elizon proved standing at the time of trial and when it should obtain, or summary judgment, which obtained final summary judgment of foreclosure. Now we're talking about damages. So in other words, you said you weren't given the opportunity to file a motion for voluntary dismissal based on standing. What you would have, or you tried?
We did mention standing, Your Honor, and that may not be the case. So we attempted to raise all of the failures of the appellant's evidence that they presented or the lack thereof. And in the midst of that, the court cursorily.
So let's back up for a second. So wouldn't it be, I don't want to, what word I should use, be interesting if the plaintiff, who was a successor in interest to another plaintiff who had obtained a final summary judgment of foreclosure, at least entitlement to foreclose, absent an establishment of the non-indebtedness and damages, and which included admitting the note at trial, right? And then there's a trial on damages, and you say, hey, you know what? I want to move from voluntary dismissal because they didn't include in their case in chief on damages admission of the note that was already admitted during the first trial. And then the court said, no, I'm not hearing that. And then we're supposed to reverse let's just maybe be practical for a minute. If the court had heard that, couldn't they have just said, oh, I'm sorry, can we reopen our case and admit the note? I didn't know we had to reestablish standing. There's a lot of sandbagging and sort of gotcha going on here, it sounds to me. And I can get to some other gotcha in a minute, but what do you say to that?
Well, Your Honor, I would contend that the standing was plainly at issue. It was hard fought at this court. It was hard fought the first time.
No, I'm talking about in the trial on damages.
Yes, Your Honor. And yeah, okay. I would point out that standing need not be raised again once it's been placed at issue. The case on that point in particular would be, I believe it's Winchell. That was Winchell versus PennyMac Corp. That's a second DCA case from 2017. And this court has described standing as something of a legal oddity. That is, once put at issue by a defendant, standing becomes part of the prima facie case a foreclosure plaintiff must prove in order to secure judgment.
Mr. Hayes, just to inform you, you're at the 4.5 minute mark. You want to save that for rebuttal? You want to keep going? It's up to you.
I want to make sure that I've, thank you, Your Honor. I want to make sure that I've responded to Judge Atkinson's questions properly and fully. And so, Your Honor, in addition to the matter having been raised certainly before the trial on damages, I do want to just point out that at no time was the original of any of the documents that were required to show this plaintiff's standing introduced in the record. And the entirety of the first trial did not include evidence related to standing. That is, that didn't include original notes. It was on the first trial that was never introduced. The plaintiff at that time relied entirely on the summary judgment record, which again, as we pointed out in the briefs, relying on the summary judgment record is not appropriate at this stage. So with that, I'll reserve the rest of my time.
You have 3.5.
Unless Judge Atkinson has some additional follow-up.
Go ahead. No, it's your argument.
If there's no further questions, I'll reserve the rest of my time.
I'll still save you 3.5.
Thank you.
Mr. Poppy, you got 3.5.
Thank you, Your Honor. Very quickly, with regards to usury and the argument about consideration, I think the Jersey Palmer case has been misconstrued here. When you're talking about consideration, you're talking about consideration to enter into the contract, For example, in that case, there was an equity interest in the business. Typically, it's loan origination fees, that type of thing. You're not talking about remedies or additional damages that are part of that calculation. I would also make sure the court is aware that when we're talking about usury and we're talking about the interest rate, in that 2018 final judgment, interest was awarded at the default rate of 25% and calculated in the same manner in which it was calculated now. So the appellee was clearly aware that we were seeking default interest going way back to 2018. Again, the hearing that happened over the course of the 3 days was solely and purely limited to the question of affixing damages. All the other issues had been decided in the case. That was clearly what the trial judge said at the beginning of this case. We cited that portion in our brief. I won't belabor it. So it was purely a question of damages, and all other issues had been decided. As for issues of standing, this went up before this court. The predecessor had determined, or this court had determined that the predecessor had standing. The original note, the original launch, they were all submitted and all on the record going up to the court on that appeal. We executed an assignment, and we've cited a number of cases that say that the assignment is sufficient to accord standing for us. Going back, I want to address the issues that I was talking about in the beginning in my opening with regards to whether or not this court finds that there's insufficient evidence or inadmissible evidence with regards to the unpaid principal balance. I think the appropriate thing to do would be to remand based on equity, based on what is in the record, to go back and fix this. And I say that, as you've indicated, there's no issue here with regards to default. There's been no defenses really asserted with regards to liability. There's no defenses about payment, and that they've all been about standing, assignment, and all of that. So from an equity standpoint, involuntary dismissal constitutes a total forfeiture when there's admitted failure to pay and admitted balance due. As far as the record, Mr. Geigel clearly testified that he reviewed payment history. So there is some payment history there. We do have account statements that were submitted. I know they were submitted in the other case in chief. The appellee.
You're at a half minute to go.
I'm sorry, Your Honor, my time is up.
You have a half minute to go, 30 seconds.
So
Let me ask you one thing. I have it in my mind that the principal amount due was agreed to by the parties. Was it not agreed to?
Well, our client indicated on redirect that he would agree to that lower amount that's in the account statements. The court clearly indicated when the appellee was introducing those records into evidence and using them as part of its examination of its witness that, look, he's already agreed to the amount owed, so you don't need to use this to show that there's a lower amount. So I think in the court's mind and in our mind, there was clearly an agreement as to we were all going to accept this lower amount. There was no other evidence saying there was any amount owed. I think that's possibility in a way that this court can sustain the judge's ruling. I think it also goes to the question of what do we do if you find that there's an issue here with regards to remand and understanding this evidence, no evidence issue. I'm sorry, Your Honor.
Mr. Poppy, I did let you go over. Did you finish your answer?
Do you mind, Judge, follow up on Judge Black's question?
Yes.
Did you finish the answer?
I believe I finished the answer, but I believe I'm being asked another question.
All right. I'm going to have to give the other side an extra minute now. So you're out of time.
Judge Atkinson had a question.
Did you have a question, Judge Atkinson?
I was wondering if I could follow up on Judge Black's question.
We'll just keep going. I'll give the other side the same amount of time.
The trial court, my recollection is that, asked if the lender had stipulated to the lower amount of indebtedness, and the debtor's attorney and said, indeed not. Was that a rejection of the trial court's inquiry about whether there had been a stipulation?
No, I believe indeed, because indeed, if you look at the definition of indeed, it's confirmation. So the exact colloquy back and forth was, the court said, if you're indicating in your question about the lower amount, Mr. Geigel's already indicated he'll accept the lower amount. So if that's what you're introducing these statements to show, there's no need for that. And then he says, indeed not, meaning there's already an agreement as the amount. I don't need to submit these for showing the lower amount. And he goes on to try to use them with his witness to talk about the waiver issue. So
When you said, so indeed not, was, you're saying on part of counsel for the appellee was, indeed, I do not need to introduce them to refute his case because he has already agreed with me that it's the lower amount?
that's the lower amount.
your reading?
That's our position. That's correct.
Okay.
Yeah.
All right, is that done? Thank you for your argument, Mr. Hayes. I'm going to give you 6 minutes to equalize the time.
Thank you, Judge. And to follow up, I do want to rebut the last factual point. One, it's a strange interpretation of the phrase indeed not, and of the interaction between counsel and the trial court. Additionally, we went on to specifically provide that the 1,105,000 number itself was a question mark. And we objected to that amount. That is an inflated amount by some number. I would point this court to its most recent case on this issue, which is a 2021 case, finding that even failure to introduce a part of the payment history is a failure and results in an involuntary dismissal at the trial court. And in this case, not a single portion of that was introduced. There were payments that appellee, while we didn't make them, the receiver made them out of cash flows. We were entitled to credit for those payments introduced in that. That is, the 1,105,000 was never agreed to by the appellee. We introduced those records solely to reflect the waiver that had occurred as of 2015. Payments that had occurred after 2015 that we were entitled to credit for were never accounted for. And they simply failed to evidence what the principal amount properly should have been. Additionally, I do want to touch back on the usury issue. One of the problems.
Real quick, indeed not, Your Honor. In addition to the lower amount, we would provide evidence of your affirmative defense. In other words, indeed not. Indeed, I do not need to introduce those statements to show the lower amount. But in addition to the lower amount, we would provide evidence of our affirmative defenses. Does that support the other reading?
It supports that other reading, but Your Honor, if you continue on, we did in fact object to whether or not the principal amount had been established. We did not introduce, and had it been established, it was established as of at the latest 2015, as the trial court opined.
Your point, but your ultimate point is that it does not constitute a stipulation. But I don't want to take up more of your argument. I'll let you go on.
Thank you, Your Honor. And I do think that there's been a number of statements that possibly this wasn't as fleshed out in the papers as it could have been. So the appellant cherry picks the one holding related to findings of usury, findings of whether or not there was a waiver in this case. And we cited to some cases or to some of the court's holdings. I also just wanted to cite briefly on the November 13th, 2020 interaction with the court expressly held that it noted for the record that it considered all of the exhibits, including the trial exhibits, which counsel has not really referred to during this hearing, but they are pertinent as well.
Okay, but those exhibits, though, if you want to talk about that, the 5% documents, we can perhaps call them.
Yes,
in
sir.
Which of those documents did it suggest that the default rate was 5%?
The signed copy, Your Honor, with the wet ink signature would be on page 4728 and 4729 of the record. That expressly referred to a 5% interest rate. All of these that refer to an interest rate refer to a 5% or lower interest rate. All of them occurred after the purported default.
But did they say, this is the default rate?
One of them did, Your Honor. That one does not have a signature. I did want to touch briefly on that issue. So in particular, the statute that defines whether or not a document is signed, first, there is no requirement for a signed writing. The note at issue requires an executed writing. We do have signed writings in this case. Per statute, that is per the general provisions of the Uniform Commercial Code.
Let me pause for a second. Let's assume that it was executed and that satisfies the So you are relying on the provision of the of is it the non-waiver provision? Was it called of the what are we referring to it as in the note?
I believe it's an anti-waiver provision.
Anti-waiver provision, yeah. So that, which is essentially, are you essentially, is your argument tantamount to saying that this was a innovation, or this was an actual amendment mutually agreed to by the parties of the contract, which, in other words, that the lender abrogated its right to default rate by virtue of this one document?
Your Honor, I would contend that the court was entitled, based on the evidence before it, to find either an estoppel or a waiver, which we argued very strenuously at the trial court and attempted to introduce evidence related to that. I would point the court to Source Track LLC versus Ariba, where the court lays out expressly the distinctions between an equitable estoppel and a waiver. Those documents constitute both. The elements to an estoppel, as the court's aware, is making a representation about a material statement of fact that is contrary to a position it later asserts. Plainly, these refer to a 5% default interest rate. Later, 25% is a purported maximum legal rate. And the party seeking estoppel detrimentally relied. But the court goes on to state that
what was the detrimental reliance?
In this case, the detrimental reliance was continuing to litigate the case and by foregoing. So
in other words, that your point is that they would have perhaps settled if they'd known that, if they had any inclination to believe the lender was going to seek the 25% default rate. Your inclination is that they inferred from these documents, all but one of which just repeated what the promissory note said, which is, hey, there's the 5% or whatever, that constituted something on which the borrower detrimentally relied and continuing to litigate, and that's the type of detrimental reliance that can support estoppel.
We've also
Hey, I don't want to stop you. I'm not going to. I'm going to tell you, since you're out of time, I'll let you finish your answer to that question. Then you're out of time. Okay.
Thank you, Your Honor. As we proffered, we also, in addition to continuing to litigate, we entirely forewent discovery in the matter, which certainly would not have occurred, and mediation occurred without there ever having been an assertion of the 25% rate. I also want to be clear that the complaint asserted only a 3% interest rate. If you calculate the interest rate at that time, the 5% represented what the parties believed to be a default interest rate.
I can't give the other side more time, so I think I'm going to call it. We're done. Thank you, gentlemen.
Thank you very much. Happy holidays to everyone. It was a pleasure.
Thank you. Vice versa.